Good morning. Welcome to today's webinar. My name is Chris Justice, and I'm joined here with my colleague, Kim Smith. And today we'll be talking about everything termination provisions. So we'll be looking at some cases where the court has looked at a variety of termination provisions and what they've had to say about them. We'll also be providing tips for both employers and employees with respect to termination provisions, things that they need to be aware of, look out for, etc. But before that, we will begin with a bit of an overview on termination provisions themselves, as well as some key principles and concepts related to provisions. But before we begin that, I just want to make a point of saying that with respect to this particular webinar, we're going to be focusing on employees who are non-unionized, who work for a provincially regulated employer, in other words, someone who an employer who would be subject to the Ontario Employment Standards Act, and an employee in this context who's been let go without cause. So with that said, I will begin with a bit of an overview on termination provisions. So the starting presumption when someone's let go or terminated without cause is that they are entitled to reasonable notice, and that means reasonable notice at common law. And later on, we'll be discussing a little bit about what exactly that entails, but that's the starting presumption. Now, one way or the main way in which that presumption can be rebutted is if there is a contract with a termination clause in it that effectively limits an employee's entitlements to something less than that which they're owed under common law. And I suppose from an employer's perspective, most ideally, a clause that restricts the employee's entitlements to the minimum obligations that employer has under the Ontario Employment Standards Act, which I'll be referring to as the ESA going forward. So termination provisions themselves can be drafted in a number of ways. For example, the provision itself could reference the Ontario Employment Standards Act, the ESA, or it could actually specify a specific amount of notice. For instance, if you complete 1 year of service, you'll get X amount of months, and for every year after that, you'll get Y. Either way, it can be done a number of ways or somewhere in between those two. But what employers and employees should know is that to the extent that there is any ambiguity in these provisions, that the courts have often typically sided with the employee, and that the provision in question is interpreted in the employee's favor. And with that said, I will turn it over to Kim, who will talk a little bit about some of the principles and guidelines coming from the court, and it'll help probably establish why exactly there is a bit of a preference to favor the employee. Kim?
Okay, thanks, Chris. So I'm going to review 8 key principles that have come from various decisions of Court of Appeal as well as the Supreme Court of Canada. And so as Chris mentioned, with a termination clause, that could reasonably be interpreted in more than one way, the courts are going to favor an interpretation as against the employer and to the benefit of the employee. So I'm going to sort of discuss why that is. So, basically, courts have recognized that employment contracts are not like any other commercial agreement. Why? And employment is a means of financial support for individuals. It provides individuals with a contributory role in society, and it's an essential part of one's identity and self-worth and emotional well-being. So, and at termination, a person is most vulnerable and in need of protection. And this is also coupled with the fact that the typical employee is not familiar with the employment standards contained in the Employment Standards Act, and therefore may not seek to challenge unlawful termination clauses. And as we all know, typically, in most cases, there is less bargaining power as it relates to an employer with respect to an employee. And sort of the last principle is that the ESA, it's remedial legislation. So it's intended to protect the interests of employees, and courts are going to favor an interpretation that encourages employers to comply with the minimum standards as contained in employment legislation, as far as to protect as many people as possible, as opposed to not. So I'm going to hand over to Chris now, and he's going to go over what are the minimum entitlements under the Employment Standards Act.
Yeah, so we've been talking about termination provisions and what they're usually attempting to do, which is to, in many cases, as Kim mentioned, restrict the employee to the bare minimums under the statute. And so I'm just going to briefly talk about exactly what the statute says in regards to notice and severance before Kim touches on the common law entitlements that an employee may have upon termination. So I mentioned the ESA is the applicable statute that we're looking at, and the one that governs an employee's entitlements and an employer's obligations at minimum in the event that they are let go without cause. There are two concepts that you should be aware of, that being notice and severance, both of which are designed to provide the employee with either notice ahead of time or pay in lieu of notice to allow them to go and seek alternate employment. So with respect to notice under the ESA, it's essentially a week's worth of notice for every completed year of service, up to a maximum of 8 weeks. It's applicable to any employee who's let go without cause, provided that they've at least completed 3 months of employment with the employer. And again, the cap is 8 weeks. And this can be provided for by way of working notice. It can be provided for by way of pay in lieu of notice, or a combination of the two. And in addition to notice under the ESA, there's also a term called severance, which is an additional week for every completed year of service, except whereas notice has a cap of 8 weeks, severance has a maximum of 26 weeks. So the total combined notice and severance that would be owed under the ESA would be 34 weeks or just shy of 8 months. Now, unlike notice, severance under the ESA is only applicable in the event that the employee works for the company for at least 5 years and the company in question has to have a payroll in Ontario of at least $2.5 million. So if either one of these conditions are not met, regardless of how long, if the second condition, I should say, is not met, regardless of how long the employee's been with the company, they would not be technically entitled to severance under the ESA. So with that said, I'll turn it over to Kim now, who will talk about the entitlements under the common law.
Thanks, Chris. That was a great summary of the entitlements under the ESA. As mentioned, I'm going to review the factors that the courts consider when determining reasonable notice at common law, as opposed to in the legislation. Now, these factors originated in a somewhat dated case. It's the 1960 case of Bartle versus Globe and Mail Limited. However, the courts continue to apply these factors till today. Now, there are four, the first one being the character of employment. Now, there has been some comment from the Court of Appeal recently that the character of employment is a factor of declining importance. Now, historically, high-level senior employees such as VPs or execs with highly specialized skill set would receive higher notice periods on the assumption that there are fewer opportunities for work in their field. Whereas a lower skilled employee with a generalized skill set would be entitled to less notice. However, the idea that lower skilled workers are entitled to less notice because they have an easier time finding work, now that's being questioned. And at least one case has described this notion as an empirically challenged proposition. In fact, the argument is now being made that employees with marketable skills are more valuable to their employers and should have an easier time finding work. Whereas lower skilled employees, oftentimes their skill set is subject to automation. So I would say this is a factor to watch, as it appears that arguments can be made on both sides. Now, the second factor I'm going to discuss is length of service. Now, generally speaking, longer service employees are entitled to longer notice periods. For example, if one has been with the company for a shorter period of time, there is always going to be a minimum time required to seek and obtain alternate work. So the result tends to be that short-term employees, especially those with 0 to 5 years of service, end up with a disproportionately longer notice periods relative to their length of service. So the other factor that I'm going to discuss is age. So usually it's understood generally that a longer notice period will be justified for older employees. The reality is that ageism is a hindrance to finding work, and the Supreme Court has recognized this, and they've said that we can take judicial notice that employees over the age of 45 will have a harder time finding work. I would say, though, based on our experience in practice, that age becomes a stronger factor on the low end at around the age of 50, and becomes especially significant as of the age of 55 and up. However, so we agree that after the age of 45, you will face some challenges, but obviously as you go higher and higher in age, you're going to face more challenges, and you're going to be entitled to a longer notice period to account for that extra added difficulty. And the final factor that I'm going to briefly discuss is just that the courts are going to take into consideration the availability of similar employment, and they're going to consider this in light of the employee's skill set. Now, these are just the 4 Bartle factors. There are other factors that can and do play a role in determining reasonable notice. It is an individualized assessment. However, these 4 factors will always be considered in any determination of reasonable notice.
So just to illustrate then by way of an example of the difference between what the statute says on one hand or provides for at minimum and what the common law could potentially provide for, I'll just illustrate it by way of a quick example. Imagine that someone works for a very small company, so not a company that would have that payroll of 2.5 million or greater, and therefore not a company that under the ESA would be obligated to provide severance pay. And they have an employee who's been working there for 30 years, who is in their 60s, and who was let go without cause. If that employee signed a contract with a termination provision that does effectively limit that person to the minimums under the ESA and nothing further, then even though they may have worked there for 30 years and be in their 60s when they're let go, they could potentially be withheld to only 8 weeks of notice or pay in lieu of notice, or a combination of the two. Contrast that with the same exact scenario, except that in this case, the employee did not sign a contract, or did, but there is either no termination provision or the provision in question is faulty, to say the least. That same employee could be entitled to as much as 24 months, or if recent case law is to be considered, even as high as 36 months. So it's really the difference between 8 weeks at minimum under the ESA versus 2 or more years potentially, depending on whether and to what extent they find work after they let go, which just again stresses the importance all around that a well-drafted termination provision can really go a long way as far as limiting an employer's costs and potential exposure, and as well affecting the employee quite significantly. So what it obviously comes down to at the end of the day, always with these types of issues, is whether or not the termination provision in question is actually drafted in a way that does sufficiently rebut the common law presumption that that employee is entitled to reasonable notice. And so now Kim and I will look at a number of cases where the courts have looked at several different versions of termination provisions and sort of discuss what the outcome was based on those provisions. And with that, I'll turn the floor back over to Kim.
Okay, so as mentioned, we're going to look at some cases. Now, just want to point out, if a provision or a clause contravenes the Employment Standards Act, the common law will not be rebutted. Hence, the common law will apply. So in the first case that I'm going to look at, it's an Ontario Court of Appeal case, 2017. In this case, the employee earned a salary as well as commission. Now, underneath the clause, or in the clause rather, it provided for only the payment of, and it used the word base salary. So on its face, this excludes commissions, and hence it contravenes the Employment Standards Act. And for that reason, the common law was not rebutted, and the reasonable notice period at common law was found to apply. Now, the second case I'm going to look at is a 2018 case. Now, so one of the ways to ensure, at least attempt to ensure, that the clause will apply, or the agreed amounts will apply, as opposed to any other, the ESA, or sorry, opposed to reasonable notice, is to ensure they use limiting language. So now, in this case, the employee was entitled to pay, termination pay, severance, as well as benefits. Now, when mentioning benefits, the clause stipulated that the employee would be entitled to it for the minimum period as required by the ESA. Now, when the clause goes on to speak about termination and severance, it only states that it'll be paid pursuant to the ESA. So for benefits, they use the word minimum for the minimum period, but for termination and severance, there's no such limiting language. And so it's also an inconsistent use of language. If you're going to use limiting language with respect to entitlements, you should be using them consistently throughout the clause. And now for that reason, it was found to be ambiguous, and the clause did not rebut the common law presumption of reasonable notice. Okay, so the next case I'm going to look at is an Ontario Court of Appeal case, and it's a 2017 case. Now, this clause, it used limiting language, but the clause did not include benefits and severance. So as I mentioned previously, limiting language is a useful tool, but in this case, the clause stated that, and I'll quote here, the company shall not be obliged to make any payments other than those provided for in the paragraph. Well, what's contained in the paragraph? The problem was that the particular paragraph it referred to did not include or allow for the payment of benefits and severance, which are both employment standards, and hence you can't contract out of that, and it's a violation of the ESA. So if you're going to limit entitlements, make sure that those limits meet the minimum requirements of the ESA, or else the common law will not be rebutted. So the next case I'm going to look at is a 2014 case. And again here, the court found that because the clause did not explicitly allow for the continuance of benefits, or at least it found that it was ambiguous with respect to whether or not it did, it violated the ESA, and it did not rebut the common law presumption of reasonable notice. And the other case, final case I'm going to look at is a 2016 case. It's a Nova Scotia case. Now, the clause here stated that the entitlements would be in accordance with the provincial employment standards legislation. Now, the problem with the word accordance is that it's taken to mean that it would be consistent with the legislation, not that it necessarily intended for only the statutory minimum to apply. Now, another possible reason why this clause may not have held up was because here it did not mention benefits as well.
And with that said, I'll first address a couple cases, or a case at least, that also failed to reference benefits, the provision in question. But in this case, and it's Nemeth and Hatch, it's a 2018 Ontario Court of Appeal decision. In that case, the clause in question did reference minimum notice in accordance with the applicable labor legislation, so somewhat vague there. But it didn't say anything further as far as benefits. And in that particular case, the court had deemed the clause to be enforceable in rebutting the common law. And one of the comments from the court was that unlike some of the previous cases that were put before it, in this particular case, Nemeth and Hatch, the clause did not have a limiting type sentence at the end of it to say that this is all you are entitled to. So because in that sense, the contract was left somewhat open-ended, the court had determined in using some of the reasoning from some previous cases as well, that the company, the intention of the company was not to specifically exclude the common law, and so it was upheld. So this case represents sort of a general understanding of the law, in that it's never quite sure or guaranteed that there's going to be one particular outcome for similar cases, and just further illustrates sort of the precarious nature of the law as far as it relates to the interpretation of contracts. I'm going to move now into provisions that may breach the ESA in the future. So these are provisions that perhaps at the time someone is let go may not technically breach the Employment Standards Act, but if there is a possibility that the Employment Standards Act would be breached in the future, even if it's a hypothetical at the time the contract's signed, there's a risk that the court will hold that clause to be unenforceable. Now, on the flip side of that, it's possible that the court could uphold the clause. As I mentioned, the nature of law is such that it's not always clear, of course. And one such case is Ford and Keegan. It's a 2014 case. And in that case, the clause in question essentially allowed either party to terminate the contract upon 30 days notice. And I mentioned at the outset that ESA notice goes up to 8 weeks. So it's quite possible that if the employee would sign that contract, was let go after, say, 3.5 years, which in Ford and Keegan was the case, that under the ESA, if they didn't complete 3 years, they would be entitled to 3 weeks. So a clause that allows each party to terminate on 30 days notice would technically satisfy that notice requirement. But hypothetically, had that employee stayed there for 10 years or 20 years, the issue is that clause wouldn't have been enforced. So that's a potential breach. But as I said, in Ford and Keegan, this was an example of a case where despite that, the court said, well, this isn't an employee who has that length of service, and based on the timing of when he was let go, the amount of notice set out in the clause was sufficient, and therefore the court ended up upholding the clause to rebut the common law principle. Now, contrast that with a later decision, Garrett and Complete Innovations, which is a 2016 decision. Same kind of situation. There was a contract that set out a specific amount of notice being provided, and in Garrett specifically, it allowed for a maximum of 8 weeks of notice, depending on how many years of service had been completed. And it also mentioned that the benefits would continue for that period of time. However, it didn't really mention anything beyond that. So again, it's a situation where depending on when the termination happened, sure, that clause could technically have been on side with the law, but because it's limited to only 8 weeks, had the employee worked for, say, 20 years, and that employer might have been a severance paying employer, well, then they would have owed severance as well. So again, it's a situation where hypothetically it could run contrary to the ESA. And it was on that basis that the court, unlike in Ford and Keegan, ruled that the termination clause in question was unenforceable. And frankly, I think that's the state of the law, in that a potential breach in the future is likely going to amount to that clause being set aside. So it always needs to be considered at the time the contract is signed. Is there such a scenario like that could be envisioned? And if so, then the contract needs to be redrafted, because it's always best to err on the side of caution, notwithstanding some earlier decisions that may have resulted in the win for the employer. Moving on, I'll talk about quickly, this isn't so much pertaining to language used in the termination clause, but more so when the contract in question is signed. So we always recommend, of course, that you sign a contract before, or that an employee signs a contract before they start work. And the reason for that is, I can illustrate by way of an example. Let's say you've been working somewhere for a year and someone comes to you and says, hey, I know you've been here for a year. We didn't have you sign the contract when you started, so can you please sign it? It's a technicality. Just sign it and get it over with. Well, the issue is, up until that point, that employee was provided with remuneration, was provided with a list of duties and responsibilities, a certain amount of vacation, etc. So that employee, a year later, signing a contract that merely confirms what he's already being provided or she's already being provided, is not really giving any further benefit to the employee. And likely, it's only going to be beneficial to the employer, because that contract may also have a termination provision in it, which could be enforceable. So essentially, the employee is signing something with a termination provision included, which up until that point was not in play. And again, the presumption would have been common law, and but they're not getting any benefit for their signature. So there's what's called a lack of consideration there. And there's a case, Hobbs and TDI Canada Limited in 2004, which reflects this particular situation, where the court had commented that there needs to be consideration at the time the contract is signed, and that if you're going to essentially have someone sign something later and provide no further benefit to them at that time, it's not going to be enforceable. So it's always recommended that if that's the case, that the employee be provided with some sort of additional benefit, whether it's a payment or something, just in exchange for them signing something that could limit their rights upon termination. The last case we're going to talk about is one which pertains particularly to cases where the termination provision has sort of a fixed amount included in it. So, for instance, it could be one that says, if we terminate you within the first year, you get 10 months, and every year after an additional month. So in those cases where there's a fixed amount of severance that's specified or notice that's specified, it's always recommended that the contract also include a clause on mitigation. In other words, the employee's obligation to go out and look for work. So there's a general obligation in law for employees who are let go to do that. And that's the case with respect to termination clauses that aren't as specific as, say, a particular amount of months. But where they are that specific and there is no clause about this obligation being on the employee to go out and look for work, and should that happen, maybe the employer can recoup some of the money. If there's nothing like that in there, then in this scenario where you give a fixed amount of notice or severance, the employee is owed that regardless, and there's no obligation on them to go out and look for work or have any sort of earnings post-termination affect that settlement. So this was sort of illustrated in the case of Bose and Goss Power Products, which is a 2012 Ontario Court of Appeal decision. And that's exactly the case, is that the employee was provided with a fixed amount of notice, and when the employee was let go, the argument was made that some of that should be sort of deducted based on whatever earnings they made in the future. But because the contract didn't have a clause speaking to that, the employee was essentially entitled to all the notice without being obligated to go and look for work or have that in some way affect their entitlement. So just another consideration for employees and employers alike to be aware of and consider before offering a contract with a fixed term like that in there. So with that said, that sort of concludes our discussion on the case law. And as I mentioned, we're now going to talk about some general tips. There may be some overlap based on what we discussed before, but tips for both employees and employers just to keep in mind of and be aware of when it comes to termination provisions. And for that, I will turn it over to Kim.
Okay, great. So I'm going to look at just a couple tips, or 3 tips rather, for employees in the employment law context. Now, when you are reviewing a employment contract, just because it mentions that it's pursuant to the ESA or it's only pursuant to the ESA, don't assume that you cannot negotiate for an amount that's in excess of the Employment Standards Act. Those are minimum requirements. You know, as I said, it's remedial legislation. It provides for minimal protection. However, consider your common law rights and be aware of those and seek to, if possible, incorporate that, and don't just assume that what you're being provided for, because it's legally compliant, is the most benefit that you can expect to gain. So the other issue similar to this is, if you're a senior executive, chances are that you have a little bit more bargaining power vis-a-vis the employer than, say, a lower skilled employee might have. So that's something that you can use to your advantage as far as negotiating a fixed reasonable notice period within the contract, because like I mentioned, the ESA provides for minimum requirements. However, you might be able to negotiate with your bargaining power a notice period that's in excess of even what you might be able to attain at common law. So it's definitely to your benefit, depending on the type of position and the leverage that you might have to negotiate for entitlements in excess of what you might otherwise be entitled to at common law. And that gives you some amount of certainty in the employment process of what will happen on termination. And lastly, and this goes without saying almost, but always seek legal advice. You know, prior to signing a contract, when you start with the company, or accepting a termination package. You know, companies might try to have you sign a release upon offering you a termination package, but seek legal advice, make sure that it's compliant, and make sure that you're getting exactly what it is that you're entitled to.
Yeah, thank you, Kim. And as far as employers are concerned, just a few tips. Number one, again, goes without saying, always keep your contracts up to date. Don't assume that just because, for instance, you might have had a lawyer look at it and draft it and it was fully enforceable a year previous, that this year all of a sudden it's going to be the same result. As we've sort of shown through some of the cases that we went through, you know, on one hand, you might think that the law is very settled, and then the next decision that comes out might completely contradict the line of case law that came before it. So always keep up to date, just be on the ball when it comes to that, and ensure that, that you're sort of adjusting your contracts with the changes that are coming through the courts. Number two is always make sure in your contracts that you have an independent legal advice clause, so something that says that the employee themselves have had a chance to obtain independent legal advice, and that if they don't end up doing so, then that's their prerogative and that they chose not to do so. This can avoid, obviously, any issue with the employee raising that they didn't quite understand it. So that's definitely something that needs to be included. Give the employee as well a sufficient amount of time to review the contract and return it to you, because the last thing that you want is for them to claim some sort of duress argument that they were under pressure, which could, even if there is an enforceable provision in the contract, possibly be fatal to the contract itself. And lastly, I'll just mention a point about severability provisions. So this is a provision that I see often in contracts. It's usually near the end, and it basically says, to the extent that there is anything in the contract that does offend the ESA or that is in some way illegal, that particular section or paragraph or sentence can be severed from the contract, and therefore the remainder of the contract can be sort of allowed to be upheld. It's very important that you do that, and I say that for this reason. Linking it back to termination provisions, let's say that you have a termination provision that deals with instances where someone's been let go for cause and also without cause, which is very commonly seen. Make sure that they're not all in the same literal paragraph. Try to break them out. So have one paragraph talk about without cause and another paragraph talk about with cause. Just sort of break them down into sections. Because that way the severability provision can sort of operate to better effect. Whereas if everything is lumped in together and say the without cause part happens to be in the same paragraph as another part of the contract that for whatever reason is against the law, and it may not even be with respect to ESA, but just contrary to the minimum requirements, because everything was lumped into the same paragraph, the whole paragraph might be severed, and the without cause part may also be thrown out. Thereby entitling to the employee to reasonable notice. So have a severability provision and make sure that the termination provisions themselves are sort of separated by paragraphs. With that said, those are our comments with respect to termination provisions. Of course, if you have any questions, we certainly welcome them. If you have any questions as far as cases we've talked about, maybe you want the names or maybe details or any general questions regarding the enforceability of termination provisions or anything sort of related to that based on what we discussed, please do email us. You can send those questions to us at socialmedia@macdonaldassociates.ca. That's MacDonald associates.ca. And we will, of course, address those questions as soon as we can. But otherwise, on behalf of myself and Kim, we thank you very much for listening to this webinar. We hope that it has provided at least some clarity to this often contentious issue of whether termination clauses are going to be upheld or not. And we look forward to any questions that any of you may have for us. So thank you very much and have a great day.